I'm Tom Shields, and I'm the Chair of Graduate Education at the university. I want to welcome you to this last section of today's program. And I'm very excited to be moderating what I hope will be a very engaging debate and conversation that we have today around the federal involvement in education and public education. I want to start by thanking, as other panelists have done, the Law Review and all the students that have worked so hard on this project. Those of us who put on conferences before know the work and the preparation that goes into this. And in particular, I think we should just give a round of applause to Joseph, who in his incredible organization skills, where is he now? I was very impressed when I met him in his conversation and what he thought would be his thinking about this last session here. I also want to thank and take a moment just to thank Gerard Robinson. As a fellow colleague here at the university, I continue to be in awe of her scholarship, her teaching, and just her overall ability to bring people into the room and have a conversation. And so I know we'll be thanking her later, but I just am so impressed with that. Like I said, it's my job here today to debate, to moderate this debate. And the question that has been posed here for this afternoon is, what role should the federal government have in the governance of public education? And we're very fortunate here to have two incredible discussants to address this issue. To my far right is Dr. Preston Green. Dr. Green is the John and Carla Klein Professor of Urban Education and the Professor of Educational Leadership and Law at the University of Connecticut School of Education. He was formerly held the Harry Lawrence Bachelet II Second Chair of Educational Administration at Penn State, where he also was the coordinator of the Educational Leadership Program. And in addition, Dr. Green was the creator of the Penn State's Joint Degree Program in Law and Education and ran the Law and Education Institute at Penn State. Dr. Green has written 4 books and numerous articles and book chapters pertaining to educational law. His extensive research focuses on the legal and policy issues pertaining to educational access and school choice. So thank you, Dr. Green, for being with us here this afternoon. We also have with us Mr. Gerard Robinson, who is a resident fellow in Education Policy Studies at the American Enterprise Institute in Washington. Mr. Robinson has been the past Commissioner of Education in Florida under Governor Rick Scott, and also was the Secretary of Education in Virginia under Governor Bob McDonnell. While in Florida, Gerard created a task force to improve learning opportunities for English language learners and students with special needs. He adopted a new competency and skill standards for STEM teachers and partnered with Microsoft to create the nation's first IT academy program that focused on middle and high school students. Mr. Robinson has spoken at many universities and organizations across the U.S. and internationally, and he's been a board member of the Gold Scholarship Program in Georgia and a founding board member of the KIPP Strive Academy in Georgia. He holds a master's degree in education from Harvard and a BA from Howard. If we can welcome both of these two for the debate this afternoon. In the lineup today, Dr. Green will be taking the pro or affirmative position on our question of whether the federal government should be involved in public education, while Mr. Robinson will be taking the con or negative position, or that the federal government should not be as involved in public education. I've taken the liberty of talking with both the camps, and they've agreed to that instead of an hour, we're going to go with the presidential model, that we're going to extend this to 3 to 4 hours. By my calculation, we should get out of here about 7 tonight. I'm not going to be Anderson Cooper or Jake Tapper, but I promise that I have a set of questions that I prepared. And so for the first 30 or 40 minutes here, I'll be asking them a series of questions, but then I want to turn it over to you, the audience, so that you can engage in this debate as well. So my first question to the attendants here is, can you address your position here in terms of the strength?
Charter schools and into vouchers, I believe that this proliferation and privatization would increase deregulation by the federal government, could really result in a disaster. We have a disaster in the making. And I've been looking at this issue for many, many years. And I've looked at how private entities such as charter schools and vouchers have made arguments as to how they are public for many ways and private for other ways. And as I've been looking at this and I'm looking at various issues of fraud and mismanagement and of how students have been treated in these organizations, I have come to the conclusion that we are in a situation that is very similar to where we were with subprime mortgages. Here is how we are there. In the subprime mortgage situation, it was carved with great intentions. We are going to try to increase participation of minorities in housing through, we're going to increase the participation of mortgages in housing. And the way that we did this in subprime was that we actually changed the rules for mortgages such that we removed this issue of risk. Under traditional mortgages, the person who issued the mortgage also held the risk. And as a result, those banks and S&Ls were very careful not to expand that to people in underrepresented groups who could not qualify for traditional mortgages. So as a result, the federal government engaged in a policy where it actually engaged in mortgage securitization. And that is that it bought, after it actually issued those mortgages, it then sold the mortgages. And as a result of this, what happened was that those original mortgagors no longer held the risk. And so they could actually issue more mortgages and then also issue them to people whom they normally would not give them to. And those included minorities and persons from underrepresented groups. In addition to this, we saw deregulation. In order to actually bring the private entities into this even more, the federal government actually removed many of the restrictions that only allowed the federal government to engage in this subprime mortgage industry. And taking advantage of this, these subprime entities then actually entered into this full force. And we eventually ended into a bubble because we did not anticipate all of the mortgage collapses that occurred as a result of this. And my argument is that we are in the same situation right now, especially with charter schools. Many charter schools, we talked about this morning, it was mentioned that many charter schools have this process called multiple organizers, multiple authorizers. These authorizers are actually created for the same purpose that mortgage securitization occurred. And it was because because school districts still had to maintain that risk by granting authorizations to charter schools. And so they were very hesitant because if things did not go well, they could actually face the voters. So a number of states and charter advocates have advocated for having multiple authorizers because they're much more willing to take chances and give charters to schools where traditional school districts will not do this. And so we actually seen a major increase in these authorizers. But the other problem that we have, though, is that in addition to this increase in authorization, actually targeting African Americans who have seen charters as an opportunity for them, what else has happened is that we don't have regulation. Remember, charters by definition are all about deregulation. And so what I have found in my research, especially in these districts where there are multiple authorizers, what we're finding is that these charters, the education management organizations have been entering into this sector in ways similar to what we have been seeing with subprime mortgages. And so what has been happening is that they're actually engaging in the same way of subprime mortgage servicers. The EMOs are actually engaging in fraud and mismanagement in systemic ways, and they're also engaging in suspensions and expulsions of students and not educating students with disabilities because of the very rational point that they cost money. And so it's not really worth it for them to make this investment. And so, so this is the problem, is that as we actually continue on this path, as was pointed out this morning, there are many school districts now in urban areas that are almost predominantly charter, New Orleans being among them, Detroit being another one that is very close. We may run into a situation where if we have this systemic fraud and mismanagement, that we could actually have a situation where all of public school education in those districts is negatively affected. So I would suggest that instead of instead of withdrawing from public education, especially in these privatized settings, the federal government, I would suggest, needs to take 3 steps. First of all, it needs to, as in the morning was discussed, enforce the various rules that apply to traditional public schools, such as Title VI, Section 504, and EEOA, the Equal Educational Opportunities Act for English language learners. Second, I would suggest the charter is that there needs to be sort of this carrot funding mechanism in the same way as Race to the Top and other activities that we've used to increase the charter school sector. But the difference here is that there needs to be an emphasis on student rights, among them protection of due process rights for students. I know it's discussed this morning about how charter schools are actually public schools. A lot of my research is on all the ways that charter schools argue in court that they're not, and how they've actually succeeded in those ways, including due process. And so what needs to happen is that there needs to be this sort of incentive through this carrot approach to make sure that states will actually provide due process for students. Thirdly, I would suggest that the federal government should actually, in future iterations of funding the charter schools, make a requirement that charter schools have to provide protection for, the charter schools have to provide requirements for authorizers, especially those multiple authorizers that are not school districts. Because in that way we can ensure that we may actually have some more oversight on those charter schools in those districts. So I just want to close in saying that I really do applaud the efforts of parents who are looking for other alternatives for education. My mother is a single parent. She raised 2 children who grew up to be professors. I'm at UConn. My brother's tenured professor at UVA. So we understand the importance that parents need to fight for education, but the federal government needs to provide protections so that those decisions will actually have meaning. Thank you.
Thank you, Dr. Green. Appreciate that. So, Mr. Robinson, are we facing a bubble? Should we deregulate our public education system?
Religion, morality, and knowledge being necessary for good government and the happiness of mankind, schools and the means of education shall forever be encouraged. 1787. We decided, even before the ink was dry, we ratified our Constitution, that the federal government believed that education was important to our nation. A young republic who thought it was important to have educated people who could then become those who help us lead a strong economic nation. 1785 in the Land Ordinance Act, we decided that Section 16, for every area, in a certain geographic area, there should be a school put in place. We said that long before Horace Mann took over schools and created the idea of what we know a state-run system in Massachusetts, and we also did it long before the founding of universities and the K-12 system. There is a role for the federal government in education, and the federal government defined its role long before it even ratified the Bill of Rights to determine the role between the government and the states, and between the states and the citizens. I like the part where it said, the means of education shall forever be encouraged. The role of the federal government is to encourage. You encourage by allowing 2 things. Number 1, allow states and local governments, those who are actually involved with the day-to-day running of school, to have the flexibility, the funding, and the room to educate students as they desire to do so. Number 2, there's a federal role for some funding. We know right now that approximately 10% of our budget comes from the federal government. We know it varies between different states. But if we allow that to happen, we do the encourage part. There are some great examples of when the federal government encouraged education. 1956 and 58, a great discussion about the role of Russia and how they seemed to make it to space before we did. There was a big push for the National Defense Act, where the federal government said it was important to now have people trained in something called STEM, that we think is all of a sudden a new idea. No, we need to have STEM in place. Number 2, we also need to make sure that we have educators who speak multiple languages. We're still one of the few countries in the world where we're not bilingual or multilingual, but there was a push to make that happen. We also know that this year we celebrate the 50th anniversary of the Elementary and Secondary Education Act. The nation's first president to actually earn a degree from a college of education, Lyndon Johnson, said that it was important not only to educate people, but to use schools as a way to fight poverty, creating what we now know as Title I. Not millions, but thousands of students in Virginia, millions of those across the nation benefit from Title I. So the idea that there is no role for education isn't one that I take. I take the means of education, schools, and the means of education shall forever be encouraged. When we see schools, we think of buildings. When we think of means of education, it's broader than buildings. And so for me, the federal government can also play a role in supporting the means of education, whether it's in a traditional public school, whether it's in a private school, because the federal government already supports private schools through something called the Elementary and Secondary Education Act through Title II. So for me, I encourage or support the encourage role, but when the federal government gets too involved, too bold, and too prescriptive, we move from encouraged to discouraged. Thank you.
Thank you, Mr. Robinson. I want to follow up now to both of you. And Mr. Robinson, you started talking about this, and I had some of those key dates and key components in our history in this country: the National Defense Act, the Education Act, Horace Mann's ideas of the common school, and on and on. We've seen, however, over time, and some are claiming this definitely in the last 12 to 13 years, much more centralization to our system and much more federal involvement in that. What are your thoughts on this, Dr. Green? Do you think this is just the course of where we are with any type of public system, that it would centralize more and more? Or do you think there's been an overreach now by the federal government in this role of education? Something that has historically happened, although we have a history of local and familial initiatives in education. Do you think the federal government has overreached its power now?
Well, I want to say that when I was thinking about this question, that I want to tweak the premise of this. And that is that understand that in the 1950s and the 1960s, when the federal government became much more involved in civil rights, the same argument was made, that the federal government was actually overstepping its role in trying to ensure student rights. And so that argument has been made with respect to that. So I think that for the last really half century, we have seen the federal government take a much more active role in ensuring that the rights of students are protected. And this includes even, in some aspects, No Child Left Behind. There were some positive aspects in No Child Left Behind, in that it took the concept of testing, which was used by a number of states to determine whether or not students were indeed learning, to think about it in terms that were designed to protect the rights of minorities. Understand that No Child Left Behind did say that that it had to disaggregate data for underrepresented or underperforming groups, such as students of color and students with disabilities. And I mention this because in 1999, 2 years before No Child Left Behind was enacted, it was found that 33 states actually did have policies that were accountability systems designed by testing to determine how well students were doing. Only six actually used addressing the racial achievement gap was a goal. So in that regard, No Child Left Behind was actually a great idea. I do think that there were some major problems in terms of how they actually did accomplish this, most notably and now sort of like it's some of the emphasis more on charter schools, and also as we move on more towards the approaches toward teacher evaluation, which in my own research I think is a really bad idea because of some of the technical problems. So I will not necessarily say that the federal government is overreaching, but I will say that unfortunately in the implementation there have been some problems.
Thank you, Dr. Green. Mr. Robinson, you have a follow-up to that and some of those thoughts about this overreaching or centralization? Is this something that you think has been happening more and more recently by the federal government, or particularly recently as No Child Left Behind? I want to address NCLB here in a moment, but any thoughts and follow-up on that to Dr. Green's points?
The concept of centralization is not endemic to the federal government. Beginning in the 1970s, there was a real big push for centralization across the board. You found states taking stronger roles in not only how they funded schools, but how they regulated schools. If you take a look at mayors and school boards and county positions, there was a stronger push for centralization. Some of that had to do with the change in labor economics in the United States in the 1970s, the role of federal, state, and local governments having to be more involved. So for me, it's just a broader conversation about centralization. But let's look at the federal government in particular. We said the 1990s. When we have to authorize or reauthorize the Elementary and Secondary Education Act, we explicitly expand the role of the federal government and how we're going to be involved in schools. I don't think the expansion in and of itself is a bad thing, but it's not the expansion that's the problem. It's the calcification of the regulations. You often have more regulations than you have money to implement. And often when you get money, the money will actually dry up long before the federal regulations do. So for me, if we want to talk about centralization, the federal government is one place to look. But at the state and local level, we need to address that issue there, because I think if we can address centralization locally and at the state level, we can do a better job with it at the state level, at the federal level.
Thank you, Mr. Robinson. To both of you, I showed the movie in my class in my first year seminar, Waiting for Superman, and I was just showing it in yesterday's class, and there's a scene where Ronald Reagan looks at the camera and he says, "I'm going to abolish the Federal Department of Education." I have a simple question for you both. Should we have a Federal Department of Education?
Would you like me to go first?
Yeah.
Yes. Yes, we should have a Federal Department of Education. I think you know I'm pro, so you know I'm going to say this. But
please, don't start messing with the format.
No, I won't do that. I won't give you a heart attack. But I want you to understand that the important role of the federal government and the Federal Department of Education is the enforcement arm of those civil rights statutes such as IDEA, Section 504, Title VI. And if you actually remove the federal government and the OCR, then you're going to say to the states, you'll do it. I'm a Virginian. My mother was a Virginian. My mother's Virginian, grew up in desegregated schools. I have major doubts about this. And I must also say that as we move towards privatization in charter schools, I would suggest that moving toward deregulation would be very, very scary. Let me give you an example. I've already explained in my talk about how charter schools aren't exactly public, in that one way that they may not be public is the requirement of due process. I'm going to give you a scenario. This is an actual case. In a case called Scott B., the California Appellate Court found that a charter school did not have to provide students with the due process right of education, in part because the charter school was a school of choice. And as such, the school of choice did not have the same due process requirements as traditional public schools. Let's extrapolate that idea now to New Orleans. Let us say that you have a school system that is all about school choice. One school says, we're not going to take that child because that child is a problem. The other schools of choice say, you know what, we don't want him either because he's a problem. Extrapolate that, and then by my analysis, actually, legally, that actually may be permissible. So if that is the case, then who steps into the breach? And this is where the federal government can step into the breach to provide protection. This is the role that the OCR would play. And so, I present this parade of horribles to point out that there's no reason to suspect that the state will actually do as it should. And that as long as the federal government provides funding for, as a tool for maintaining civil rights, then it can step in those situations. So for this reason, I do support the federal government in order to ensure that the rights of students are protected.
Thank you. Mr. Robinson, thoughts on this? Should we abolish the Federal Department of Education? And also, something that Dr. Green, who would step in this case? We heard from a great talk this morning from the Secretary. What might happen here?
So for me, the Department of Education is real simple. Do not end it, mend it. We've had a Federal Department of Education for a shorter period of time than we've actually had a government. And there's a reason for that. The Federal Department of Education, as we know it as a concept, was created in 1867. Within a year of its creation, there was a decision to move it from a federal or cabinet level position to a lower position. In that lower position, it stayed there, found itself later in the Department of the Interior, and it stayed in the Department of Interior to 1939. It then went to another federal security agency. From there, it finally moved to its own quote-unquote cabinet agency in 1953 with the creation of the Department of Health, Education, and Welfare. During that same period of time, between 1908 through 1975, there were 103 bills minimum introduced to create a federal Department of Education. That means between the time that Teddy Roosevelt was president all the way through the time, ultimately 75, with our friend from Michigan, Ford, there were bills after bills and bills introduced. Let's create a Department of Education. Democrat and Republican often said, we don't think so much, and here's why. Not because we don't support education. We obviously have states who support it, but more importantly, we're concerned that if you create a federal department, you're going to have federal mandates which are going to creep into state and local level politics. Finally, there was a compromise. Jimmy Carter became the first president of the United States to be endorsed by the National Education Association. Since its founding in 1857, he had never endorsed a candidate. But he said, we'll endorse you if you decide to support a federal Department of Education. In 1975, it introduced a report. Lo and behold, the title, The Creation of a Federal Department of Education. He wins, things move forward, he signs 96-88, and we have a department. I would say not ended, because as someone who actually had to live with the day-to-day consequences of federal policy, they actually provide a support role for the states when we need it. So there's no end role, but there should be a mend role. There's simply sometimes where the federal government asks too much of state departments of education. What I would say to the professor is, I have more faith in the states probably than you do. At some point, the federal government and the Civil Rights Division alone can't drive education. 50 million children who are in schools ultimately respond to those who elected them to office and who appointed their state leaders. States have actually done great things to address some of those issues. At times, we need to bring the federal government in. So for me, it's mended, not ended.
Dr. Green, a little follow-up here. Do you have faith in the states?
Yes, I do have faith in the states. I do have faith in the states. However, while I have faith in the states, I am concerned about the state's capacity. I mean, the capacity, because what has been happening, again, and a lot of my research right now is looking at is what's happening in privatization. What has been happening is that states have been dealing with these issues independently without any idea what is going on in other states. And so you have instances of private entities coming in and making suggestions and passing laws which go against the rights and go against the best interests of those students. And the states are just really not aware that that is going on. And so the federal government can actually help in that role of providing information and evidence and also support so that the states can do the right thing. I'm not saying that the states are, I don't want to say that they don't have the best of intentions, they just don't have the best of capacity and the best of knowledge. And so this is where the federal government and also the U.S. Department of Education can step in and help the states do the right thing.
Thank you. I'm getting ready to ask the audience for their questions. I have a couple more here, so you want to be thinking of those to engage the debaters here. I'm going to take a page out of my moderator colleagues, Anderson and Jake. I'm on a first-name basis with them, and ask, NCLB, one word, success or failure? Mr. Robinson?
Compromised.
Success or failure?
Success.
Success, all right. Dr. Green, NCLB, success or failure?
Qualified success.
Success, okay.
Yes, success.
Success, all right.
There's some agreement there. Yeah.
If this was a more academic debate, I would ask them for follow-ups, but I'm not going to. But no, I wanted to address now an issue that we don't necessarily have to deal with or think about here in the state of Virginia is Common Core. Common Core, what are your thoughts on Common Core? Should we have it? Should we have national standards? And what about the accompanying assessments that are causing parents to opt their children out or to not take these tests? Any thoughts on this? Mr. Robinson, I'll start with you. Common Core.
So in 2010, when Virginia had a chance to join the bandwagon to move forward Common Core, we said no. It was the right decision in 2010. It's equally right in 2015. Not because we don't support the concept of federal standards, but let's remember, it was states, before the administration was elected to office, who huddled together. And they said we need to create national standards. And there's a fine line of demarcation between national and federal standards. Once it became federalized, it became politicized. And so fast forward to 2015, a number of states have withdrew their participation in PARC, one of the assessment associations. Remember, in 2010, there were 23 members in PARC, plus Washington, D.C. Today, there are 12. A few days ago, Massachusetts, arguably the best performing state in the nation, its state chief decided to create a compromise. Let's have a 2.0 version, best of PARC and best of our own standards. I published a piece yesterday, and you go to AEI, if you ever need a sleep aid, go there and read some of my work. It'll help you sleep at night. But I published an article yesterday where I actually addressed the issue of why Massachusetts, at least pivoting, says a lot about what states believe Common Core could and could not do. So from a Virginia perspective, we were right. I think for some states it made a lot of sense, not for the Commonwealth, but for everyone else.
Thank you. Dr. Green?
I will preface my remarks by saying that I actually am pretty critical of Common Core. But I will say that I will make the strongest argument for it. And I think that the strongest argument for a Common Core is the fact that you do see a great deal of variation among states in terms of the skills that students need to have. And some states actually do have greater requirements than other states. And it doesn't really prepare us for competition internationally. And so therefore, the federal government, and the argument for it is that the government can then come in and then sort of set standards and approaches that will enable states actually to prepare their students to be more effective competitors internationally. So that is the strongest argument for it. And as I said, I am partly a school finance scholar. And so in my research in school finance, I have seen a great deal of variation in terms of the skills that students have and in terms of the resources that they have. Common Core actually creates that pressure that maybe will cause states to make that commitment to education, raising their curriculum in ways that can get students to compete.
Now here's one interesting follow-up. When I say there's a role for the federal government, and I call it encourage, take a look at Common Core and Race to the Top. It's likely that would not have had any gravitas if it were not for governors, educators, the business community, and the philanthropic community before the election getting together and saying we've got to find a way to make sure that a student in California and a student in Massachusetts, Louisiana, or Washington State are kind of on the same page. They push the issue. This is something I call civil society, where there's a role for government, the faith-based community, businesses, nonprofit organizations, and others. We, in many ways, drove the conversation. While it was national, it made sense. When it became federalized, it made less sense. So as we think about the role of the Department of Education and government, let's make sure there's a civil society approach, because we can often shape what the federal government should and should not do.
Thank you, Mr. Robinson. All right, I have one last question, so audience members, get ready. Last question for you both. I have others, but this is, I want to get the audience engaged. The incoming Secretary of Education, John King, has been a champion of creating policies that create diverse integrated schools. Should the federal government create policies that not just desegregate, but create integrated and diverse schools? Mr. Robinson, why don't we start with you on that thought?
So 60 years after Brown v. Board 2, 61 for Brown v. Board 1, we have a mixed result on how well we've done with integration. But that assumes that you solely look at Brown as a fight for color coding classrooms, instead of also looking at it as an opportunity for opening wider the door for opportunity for children to attend public schools that actually make sense, that are actually well cared for, and that have quality teachers. If we allow ourselves to solely focus on the color-coded classroom, I think we're going to be in big trouble, and here's why. September of this year, for the first time in American history, the majority of the students who attend public schools in our nation, and that's over 50 million, the majority of them are not white. It's going to be tough to color code classrooms when often we make the white factor the factor for desegregation as well as the other. So that's part one. Part two, there's going to have to be a realization that Brown was also a push for quality education. And there's some great quality schools here in the Commonwealth. We all know a great deal about Maggie Walker. We can talk a lot about charter schools. How about for those who say we don't like charter schools, let's agree to make every school in Virginia a Maggie Walker school. Let's just do that. And that's something we can do to maybe get toward integration and otherwise. But I think it's a losing argument to solely focus on color coding classrooms. I think better we need to look at economic integration. I think we need to look at zip code integration, and also think we need to open up the borders so that some students can actually cross the zip code or school line to get a better education somewhere else. So I'm still optimistic about Brown. I think there's more we can do to keep his spirit alive, but we have to do so in a way that works within the context of demography in 2015.
Thank you, Mr. Robinson. Dr. Green, what are your thoughts on this? You've written about this and
Yes,
studied this, but what are your thoughts?
My preface to this is that understand that Mr. King, who is now coming into the Secretary of Education, also is a big supporter of privatization and charter schools. And so what we have is that he has said that he wants desegregation. He also says that he wants choice in charters. And it's important to understand that these two issues work in conflict with one another. They can work in conflict with one another. And that is that research has shown that some of these choice programs actually are more segregative than traditional public schools. Charter schools actually tend to have higher concentrations of black students than traditional public schools. So that's important to understand as I go through this. Now, I do believe that integration is a great goal. Educational research demonstrates that there are benefits to integration, both short-term in terms of educational performance for African Americans, also long-term in terms of living in integrative environments. There is also a burgeoning research area that shows that desegregation and integration is also beneficial for white students because it prepares them for life in a more integrated setting. And so there's that benefit. However, understand that these choice policies do come in conflict. And just to address Dr. Robinson's point about the issue of quality, I want to point out that from my own research as a school finance scholar, looking at the conflict between race and school funding, what we have found is that traditionally, high minority school districts and schools tend to be underfunded, systematically underfunded up to around 5%, underfunded to the point that they do not have sufficient funding to meet their needs. So, as we give these parents the opportunity to make choices about waiting for Superman, we want to also make sure that we don't lose this other benefit of integration. And so what has to happen, and what I've written about here, is that when you have these choice programs, you also have to include the goal of integration, the goal of desegregation. So if you're going to have choice, if you're going to have charters, you also, or any other sort of magnet schools or any other of these policies, you have to think about where to locate the schools. You have to think about the school boundaries. You have to think about the school themes. And so you factor in all of these ideas about choice so that you don't lose the goal and the benefits of integration.
Thank you, Dr. Green. Both of these debaters have given us a lot to think about, and I'd like to now open it up to questions from the audience. What are your thoughts on these issues? Should the federal government be engaged in public education? What are your questions for the debate? Yes, sir, in the front here.
Mr. Green, you've expressed concern about potential due process violations by state and local governments. If a police officer armed with a warrant violates the Constitution by failing to knock and announce before he executes the warrant, the U.S. Supreme Court has held that the evidence need not be suppressed. And they've held that because they believed that the threat of other consequences, and what they had in mind was a Section 1983 suit, was sufficient to deter the police misconduct involved. Can you explain why the potential of a 1983 suit would not be sufficient to deter violations of due process rights when that Section 1983 suit comes along with not only the possibility of damages, but the obligation for the state or local government to pay the plaintiff's attorney's fees?
Okay, and this is in the context of schools, correct? Educational due process, and also about charter schools and other sort of alternative options. To have a Section 1983 suit, you have to establish that the entity is a state actor. That is a primary requirement of this. And in my research, where I've looked at charter schools and other forms of privatization, charter entities are arguing that they are not state actors. And a case called Cavaniss versus Horizon Learning Center, this is a case in Arizona where the Ninth Circuit found that a charter school did not have to provide a teacher with due process for once he was terminated, because the court found that that school is not a state actor. And in reaching that, and the court reached that conclusion even though the state statute stated that the charter school is a public school. The reason that the court reached that decision was that it said that the term public school really didn't have any meaning. And that the idea that due process automatically belongs to a public school just wasn't true. And so what the court did instead was to look at the statute and to see what was the wording of the statute. And the court concluded that the employee-employment relation was not really a part of that statute. And so therefore, because there wasn't that coercion to act as a state actor would, then there was no Section 1983 violation. And so there could not be any sort of cause of action. This is important because when you get to the issue of student discipline, charter school statutes generally say that the school will have to provide a discipline policy. It does not actually state anything about due process rights or about constitutional rights. And so that is why Section 1983 may be off the table. And so, ever since I wrote about this back in 2013, there have been two cases, one in federal court in Hawaii, and the other state appellate court in California that I just discussed, where both courts ruled that a charter school did not have to provide due process either for under the Constitution or under state law. So that is a major concern.
Can I follow up?
Yeah, please. I was going to ask you to.
So there are a couple of things to remember. When the states created charter laws, actually read the charter law. In many of them, they actually have language that you must abide by federal anti-discrimination laws, the 1964 Civil Rights Act, as well as others. There are state chiefs and superintendents who've involved themselves in closing bad charter schools because of some of the issues that you mentioned. So even in the absence of the federal government involvement itself or the Department of Education, states have taken care of that. Number two, the concept of privatization. Public school desks that our kids sit in were created by a for-profit company. The computers they use, created by a for-profit company. Often the uniforms they wear, if they choose to wear uniforms, were created by a for-profit company. And most of you in this room who have on very nice clothing, I must say, were created by for-profit companies. The children often ride on bus that are traded on Wall Street. The books that they use are for-profit companies. The teacher, superintendent, and principals who have their investments in Virginia, Massachusetts, and other state pension funds. Those funds are invested in the private market. There is little about privatization that public education isn't already involved in. Privatization is a good term to use to make us think, wow, we're moving away from the public piece. There's still a public piece, but be very clear. Most of you who are in education are going to retire on benefits that were funded by the for-profit market. I'm glad to see that there, as well as the role for bonds and government markets. But the idea that privatization is our problem, no. Low expectations is a bigger problem than that.
Can I respond to that?
Yeah, now we're getting cooking. This is, thank you. I'm going to throw all these away. So, privatization, Dr. Green,
while
what's your thoughts?
While it is true that charter school statutes say that, while many of them say that federal civil rights statutes must be followed, they don't say that student constitutional rights must be followed.
And I would tell you to take a look at the 67 school districts in the United States. Some of the largest ones actually have something called a Student's Bill of Rights or a Student Parent's Bill of Rights. There are actually some states who've actually codified that in statute so we can do it at the regulatory level versus always having to rely on the courts to step in.
They haven't been able to force that in court.
That's debatable.
I'm sure this is sparking hopefully some
But you
thoughts.
also selectively use the federal government when you talk about charters not being public and overlook the fact that over 4 states have actually decided, state Supreme Courts have decided that public charter schools are in fact public.
Can I respond to that?
Please, yes.
A lot
By
of
all
my,
means.
A lot of my research actually looks at this very question. And you might have heard Diane Ravitch talk about how charter schools like to have it both ways. This is actually developed from research that Bruce Baker and I have been engaged in that have sort of looked at the legal status of charter schools. And so what we have found in our research, in our analysis of these laws, is that charter schools emphasize their public characteristics to be eligible for funding, but they emphasize their private characteristics to avoid those pesky laws that they don't like. And so, what must happen in these situations is that state legislatures, the federal government, and the federal government can help out with this by providing incentive to prevent these sorts of things from happening. We've already seen, in addition to the case I talked about in California, you might have seen the white hat management case in Ohio. Any of you familiar with that case? This was a case where white hat management was able to avoid having to pay back or give back the equipment that it gave, that it had purchased with public money for a charter school because a contract said that, that in case of a closing, the equipment remained with the white hat management organization. And so people were very shocked and they said, wait a second, that's, but these are public institutions. But the problem is that because these institutions are in fact hybrids that combine both public and private characteristics, you end up with these types of decisions that are somewhat shocking. And so this is why you need to have the federal government engage with the state governments to provide advice as to develop charters that will actually, in addition to ensuring that there is innovation, protect the rights and concerns of school districts and parents and children.
Let's take another question from the audience. Someone else. Yes, up here.
So you kind of touched on this a little, and I'm sorry to continue on the charter school.
Please.
We talked a lot about that today. But I'm wondering your opinion on how you feel the federal government's role in incentivizing the expansion of charter schools because they are this hybrid, because they have both positive and negative aspects, and because we have both good and bad charter schools. What's your opinion on the fact that Race to the Top and other funding mechanisms incentivize states to expand their charter school laws and make it easier for these schools to proliferate?
Thank you. That was going to be my follow-up. So,
I'll go first with this. This actually goes, is it okay I go first?
Please, yeah.
This actually goes towards the research that I've been doing right now, where I have equated the idea about charter school expansion to that of subprime mortgage expansion. Because this is how it plays out. In both of these instances, the federal government did engage in policy. I mean, not the federal government, but state governments did engage in policies through multiple charter authorizers that were designed to increase expansion. And it increased expansion because these multiple authorizers were more likely to authorize than traditional school districts, in part because they didn't have that risk. If things went poorly, they were not going to be the ones who were going to be in trouble for it. And there were no authorization laws or like some super authorizer there to actually ensure that these authorizers were sanctioned if this occurred. And so both in subprime and what we're starting to see in charter schools with all of this sort of these reports on fraud and mismanagement is that you don't have the attendant requirement for regulations that go along with the expansion. And that is in Race to the Top and in the waivers and all these policies, they were very good about expanding charters, but not good at all about requiring oversight over them. And so understand, I'm not being anti-charter here, but I'm saying that if you want this to really work in a way that will have meaning for school districts and meaning for students in the future, you have to have these regulations in place, and the federal government can play that role.
So I want to answer the follow-up, Mr. Robinson, but also this thought that Dr. Green's expressing around, should there be more oversight of charters? Should there be more regulations of them? And should it be, then the question would be, should it be the federal government? Go ahead and answer, but he's had a couple thoughts now on this. Is that a concern that we should have?
So I'm going to go to the top question and then work it backwards. So President Bill Clinton is responsible for the federal expansion of charter schools. If you want to understand how we have what we have today, take a look at what he supported when he was president. His Department of Education sponsored a number of grants to give seed money to states, and states therefore gave it to local communities to create charter schools. So the federal government has been involved with that. John King, as secretary, will probably continue that. Number two, regulation. I was on a committee that helped design the National Model Charter School Law. There was a role for regulation in there, and regulations matter. And we also need to make sure that we highlight the bad actors that we have, and highlight that they were bad actors because they were bad actors, not because they happened to work in the charter school system and behave badly. I take the position of Federalist 51, if men were angels, there'd be no need for government. Since people will behave in ways that are less than angelic, there is a role for government. You're not going to have innovation by over-regulating charter schools. In fact, you find magnet schools and innovative traditional public schools who are innovative not because they have more regulation. In fact, they have less regulation. So it's easy to play the charter school card when you need to, but the reality is the majority of our children in the United States will remain in traditional public schools for a very long time. We need to make sure they work. And if you look at the traditional public schools that work, that are innovative, it's not because we've over-regulated them.
Why don't we stop there? It's after the appointed hour, and what stands between me and the debate is some wine and some food, which is always helpful on a Friday afternoon. Can we just give a round of applause to the...
That was fun.
We could have gone on to 3 to 4 hours, but I'll stop you from doing that. I don't think we should have that, but thank you so much, Mr. Robinson and Dr. Green. And again, thank you so much to the Law Review, to Joseph, and to Kimberly. We're now going to exit and celebrate the conference today and also Kimberly's new book, okay? Thank you so much for being here this afternoon.